Hello everyone, I am Dr. Dina Djuvala and I'm the convener of this seminar series called The Politics of International Law, which takes place under the auspices of the Center of International and Public Law here at the ANU College of Law. Before we get started for today and before I introduce our eminent speaker and commentator, I want to acknowledge that today myself and many of you joining, I find myself on Indigenous land. I'm usually in Canberra, but right now I'm in Sydney on the country of the Gadigal people of the Eora Nation. And I want to pay my respects to elders past, present, and emerging. And I want to acknowledge that sovereignty over this land has never been lawfully ceded, and to acknowledge the special responsibilities as, especially as the Australian National University, but as all of us lawyers who work on unceded Indigenous land. Also, before we get started, I want to acknowledge that this week, both the ANU College of Law and Cambridge are mourning the passing of Judge James Crawford. I know that Judge Crawford has been respected and loved by many of those who joined the call today, and I want to send my condolences to you all. On that note, I'm delighted today to be introducing Dr. Surabhi Ranganathan, who will be talking about, as you can see, world making on the sea. Dr. Ranganathan is a university senior lecturer at the Faculty of Law of the University of Cambridge, and she's also the deputy director of the Lauterpacht Center for International Law. Currently, and that's why it's really exciting that she's talking about this today, her research is about extending both doctrinal and critical inquiry into the depths of the ocean, into things like global commons, marine infrastructure, and technosocial imaginaries. And Surabhi does that in order to interrogate issues that are currently very hotly debated in international law, including sovereignty, territory, decolonization, the Cold War, and so on and so forth. Before that, Surabhi has been the author of the critically acclaimed Strategically Created Treaty Conflicts and the Politics of International Law, which was published by Cambridge University Press, and it was the EGIL Editor's Choice of 2015. And also, to break from the formalities, I think it's a book that is one of the best examples I know of combining doctrinal rigor with critical sensibility. For those of you who might not have read it, please do yourself a favor and do so. Her work has also appeared in eminent journals of our discipline, including the British Yearbook of International Law, the European Journal of International Law, and the American Journal of International Law. Today, Dr. Ranganathan will be in conversation with our own Professor Donald Rothwell. Professor Rothwell is a leading authority both in Australia and internationally in international law, notably in the law of the sea, the law in the polar regions, and the implementation of international law in Australia. He is the author, co-author, or editor of 22 books. You heard that right, including more recently, the International Law of the Sea with Professor Tim Stevens, and he is also the co-editor of the Australian Yearbook of International Law, and he's also my corridor neighbor. On that note, I'm going to give this floor to Surabhi, who will be talking approximately for 25 to 30 minutes, followed by a Q&A with Professor Rothwell, and hopefully at the end we will have 15 to 20 minutes for Q&A with the audience. To accelerate the Q&A process, while Dr. Ranganathan is speaking, feel free to send your questions through the Q&A function or through the chat function, and I will be reading them out loud at the end. Thank you very much, Dr. Ranganathan. Thank you so much for joining us, and the floor is yours.
Thank you so much, Dina. Like as with you, I too want to start with acknowledging that this is a week of loss. James Crawford was my PhD supervisor, and I know that he was mentor and friend to many of the people who are here in the audience. So my condolences to everyone who is grieving this week. And then, of course, thank you so much, Dina, for the invitation to speak here. And thank you, Dawn, for agreeing to chair and to comment. It is an honor to to have this opportunity to talk to all of you about my work. And I look forward to our discussion. So let me get my slides started. My topic today is, in broad terms, what was advertised, which is to say it is world making on the sea. But today I'll be presenting one aspect of it. So a more indicative title would be something like this one, The Worlds of Paul Bamela Engo, Empire, Oceans, and International Law. Let me start though with saying something about my use of the word world making. So I use the term as a way of thinking about the intense juridical activity around the ocean from the period between 1945 to 1982 and thereafter. This activity, as you know, was catalyzed by many factors, by new scientific discoveries, by new technologies, new resource scrambles, military experiments, and techno-utopian visions, some of which you see on the slide in front of you. New lawmaking was considered necessary to facilitate and to give shape to these activities. And the most intensive phase was between the late 1960s to the early 1980s, which were particularly the years of the third UN Conference on the Law of the Sea, which, as you know, adopted the 1982 UN Convention on the Law of the Sea as its outcome. The convention was a momentous document. On the one hand, it was, as it was called, a constitution for the oceans in the sense of defining and allocating rights and responsibilities in a general way across the range of ocean spaces and uses. But it also constituted the ocean in a particular sense. The convention put in place an extractive imaginary. This was effected by divisions of ocean space, by zone, by medium, by function that had the effect of simplifying the ocean, erasing the sense of it as a place of connected ecosystems, as a place of life, and rendering it up as a series of places, a concatenation of places for exploitation. Moreover, the convention made extraction a value-laden endeavor, for example, by linking the activity of seabed mining to the idea of the common heritage of mankind. So if an extractive imaginary was one outcome of the convention, there was also another. This was the outcome of a battle for what international law should be in terms of how it should be made, at whose behest, according to what values, following what bottom lines and what practices and protocols. UNCLOS 3, the third UN Conference on the Law of the Sea, at the outset was to be a forum where things were to be done differently as far as the protocols and practices of lawmaking were concerned. But we know it did not stay that way. The novel elements melted away into the water, so to speak. Now, I won't go into all of that in much more detail now. I have written about this elsewhere, and this will come up later on. For now, I want to move from world making in general to my more particular subject for the day. And I'd like to draw your attention to one man, to Paul Bamela Engo, Cameroonian lawyer, diplomat, later a judge of the International Tribunal for the Law of the Sea. Engo is, of course, part of the broader Law of the Sea story. He was a major figure at UNCLOS 3. He was chair of Committee 1, which was mandated to create a regime for seabed resources and realize the common heritage principle. But he caught my attention first because of how the literature on the conference talks about him. So you have before you on this slide one example. These are words by William Wertenbaker, a journalist. And even in a chatty account, in a two-part essay that he wrote for the New Yorker, which is an account of events and personalities full of graphic language, the descriptions of Engo are quite striking. You see here the extracts that refer to his size, his booming voice, his massive arms, and a series of negative traits.
Surabhi, can I interrupt you? Your slides are not moving. So
Oh
we're
dear.
not seeing the quote you're referring to. Apologies for interrupting, but it sounds
Oh,
like the slides are amazing and we should.
Is this, can you see it now?
I can't, I still see the first.
Oh dear. Let's see.
Now,
I'm gonna.
now we can.
Oh, now you can.
Yeah.
And do you see them as full screen, or do you see them as in a partial way?
In a partial way, but that's fine. They're big enough.
Okay, so then I'll just use this.
Apologies for interrupting.
All right. No, not at all. Thank you for telling me, because the text is actually important here. So as you see here, these are some of the extracts from Burton Baker's New Yorker essay about Ango. And you see the kind of language, right? So the language is striking. Ango is talked about as a huge man with a deep voice, as a man with massive arms. And there are a series of negative traits. He's affected to be unconcerned about the anger he arouses or the enemies he makes. He works the entire conference into a froth and is generally agreed to have delayed the conclusion of the conference by about 2 years. You see similar assessments in academic literature as well. And again, you have one example here where Barry Buzan, for example, is agreeing that Ango is at the center of some of the problems with the conclusion of the law of the sea, and particularly his work might have been so controversial as to delay the conclusion of the treaty by a significant period. And these are actually the better examples in the literature. You get much worse elsewhere. In much literature, Ango is written about as incompetent, as of poor understanding, as lazy, as jealous. And true to form, this literature is remarkably internally inconsistent. So you also get that Ango is too wily, he's far too nimble in springing surprises, in switching texts, too careerist. So he's lazy and stupid, but also wily and scheming. What blows my mind is that these assessments come hard on the heels of the publication of Edward Said's Orientalism, right? That's published in 1978. And at the same time, you're getting all of the production of this literature that is pretty much playing out those tropes. So it makes you wonder, why does the literature do this? What accounts of UNCLOS 3 and of the convention does this narrative code? And importantly, how might we read against the grain of a narrative in which this one figure is picked up, exoticized, charged with the responsibility for what had gone down at UNCLOS 3, its delay, the bad blood around the Seabed negotiations, and even the United States' eventual failure to sign, in the sense that if matters had been concluded before Reagan got elected, who knows, Carter might have signed the treaty. So one effect of the narrative is that it transfers responsibility. So now in this narrative, the US is not at fault, Republicans are not at fault, capitalists are not at fault. It is Ango who is at fault because he didn't play the game. And I'm using a British sporting metaphor here because we all know what it codes, but an American one is also useful. The reason Ango is considered as not having played the game is because Ango didn't play ball. So how might we read against the grain of this narrative? And I want to suggest here 3 ways in which we might think with Ango. To start with, we might think with Ango in terms of asking who Ango was. How might a life like his telescope larger themes, themes of empire, of migration, of capitalism? And then we might think about the ways in which Ango provides a window into world making as well as a window into the world that was made. Let me say something about each of these 3. So starting with who was Ango? Now, just to check, the slides are moving, right? You can see them shift.
Absolutely.
Wonderful. Okay, so this question of who was Ango is asked in part as an act of recovery, as this is not the kind of information we usually get about non-Western figures in the international law landscape. There is some work now on third world intellectuals and on political leaders, but figures like Ango are more elusive. They are sort of mid-level figures, difficult to trace. The archive is basically, reflects its more absences than presences. And they also leave behind much less by way of personal records. There is a striking difference in the availability of records for third world diplomats as compared to their first world counterparts. But their lives are interesting. They help us see what Emma Rothschild has called the inner lives of empires. The Angos were objects of empire with lives and circumstances shaped by shifts that they had little role or say in procuring. But they were also figures who moved within empire, who wrested agency from and through imperial structures. They built networks and families, made careers, and joined political causes. So to give you just a little flavor, the Angos lived under three empires. As German, they lived in the German Cameroon, and then as it was divided into British and French mandates, they ended up initially on the French side, but then they traveled from French Cameroon to a life in Wari, Nigeria. So this was a family, therefore, that transitioned from empires, but it also transitioned from a village to a city, moving from their village Abang to Wari, which was a port town, a hub of the British Empire. Here, globality and imperial connections came into their life with marriage. Engo's father, his mother having passed, Engo's father married a Nigerian woman who previously had had sons with an English engineer. So this family transformed into a sort of English Itsekeri Bulu family. The boys, Engo and his stepbrothers, ended up again traveling to school. They ended up in the first grammar school that was set up in the region in Benin. And from there, they moved to education in England. So the transitions from between empires, from village to city, but then also a transition from periphery to metropole, where they spent several years living in London, where Engo studied law, got called to the English bar, and nurtured his anti-colonial and Pan-Africanist leanings, as so many other West African students did through networks like the West African Students' Union. With further networks came with travel to America with a theater group where Engo would meet his first wife, herself the daughter of Caribbean immigrants to America. Later in Cameroon, Engo would marry again, this time the Francophone Ruth Tiega. So Engo also traveled apart from all of these physical travels, also traveled from obscurity of a kind to fame. He went from being an anonymous boy from a village to a major figure in Cameroon's international diplomacy, and indeed in the history of the law of the sea. All this while, he remained a quintessential outsider because he was initially a Cameroonian in Nigeria, he was then West African in England, and thereafter an Anglophone minority in Cameroon, in post-independence Cameroon, and of course, a diplomat from Africa in the context of international negotiations at the UN. He was also one of the figures who mark the transition from empire to post-colonial states. It is in a way figures like Engo who are very interesting because they are the survivors of these transitions in a way that political leaders are not. Political leaders like Nkrumah, Baleba, Azikiwe disappear in the first decade of their new states, right? For different reasons, either they're assassinated or they lose power. The transitions are ones that take these people out of the reckoning in different ways. But figures like Engo are the ones who end up compounding with the new state in different ways. They remain relevant and important, and sort of they remain part of the structures of the state, but are also sort of carriers of different politics and the new states are often, as we know, can be, in many cases, the post-colonial transition has simply been a reworking of a lot of colonial means and colonial instruments by the new state. They turn out to be quite repressive and to take on some of the same ideas and structures of the previous empire. But these figures are interesting because on the one hand, they are part of that. On the other hand, they are third worldist figures. They were shaped by things like the struggles by anti-colonial struggles, by ideas of Pan-Africanism. So there are interesting tensions in their lives that also present themselves in their work. Thinking with a figure like Engo, therefore, makes it possible to write an account of international law and international law making at multiple scales, thinking through how local, national, regional, and international contexts fit together or come together at the same time. This is meaningful because it allows us to think about the connections between state making and world making. Again, this is something that we do think about when we think with Western states. We think about the domestic circumstances of the United States, for example, as they relate to international law. But what about elsewhere, all these places with overlooked history? So let's move to Engo as a window into world making in a broader sense. Now we think usually of international lawmaking and world making as expansive projects. These are expansive projects. They're projects about states. They're about formations like the Group of 77. They're about politico-economic forces. And of course, all of that is true. That is also the story I tell in other places. But they're also at the same time projects that are compounded by intimacies, by the immediacies of conference rooms, by the material circumstances of the delegates, by inspirations that strike at particular moments, ideas that come from specific experiences. And this is all the more true for a certain kind of third world delegate. Ango, for example, is Cameroonian, but the positions of the state, so to speak, really come down to him. The state of Cameroon didn't have a department on the law of the sea. They didn't send a big team of diplomats. They didn't have very well worked out positions beforehand. It was up to Ango to think about what the seabed regime might look like, how it might work to his state's benefit, and also what it might borrow from the state or the region's own experiments with post-colonial economic ordering. And this is something that I would like to think about more carefully, which is think with Ango's own proposals, especially his many schemes for joint ventures for seabed mining, in answer to one of the most hotly contested questions, which was who should be able to exploit the seabed, and think about how that might relate to Cameroon and the region's own experiments with ideas of the mixed economy, for example. Working with Ango, we get also insight into other struggles, the struggle to establish common knowledge about the seabed and establish common politico-economic bottom lines. We see through some of the drama and some of the descriptions of Ango where the centers of the conference might actually have been. Certainly they were outside of the official plenaries. We also see how interpersonal dynamics, likes or dislikes of Ango himself, get translated into general narratives about the third world. And finally, another thing we get to see is the way in which places like Committee 1 of UNCLOS 3, or any of the other committees indeed, might have worked as theaters of anti-colonial politics of the time. These are less familiar places compared to something like, say, the Special Committee Against Apartheid that Ango's Nigerian stepbrother was actually chairing at the same time at the UN. Those are the venues that we usually look at as sites for political speech about empire, discrimination, racism, equality, etc. But these committees, like the Seabed Committee, are also sites where things were being worked out in terms of what all of this would mean in a practical sense, in terms of sharing natural resources and regulating the international economic order. So Ango is a window into all of these questions about world making, but equally he's also a window into what happens. So we have on the one hand this drive to make this new international economic order, make this new world, but there is a world that gets made, and that looks quite different from the world that people are trying to make. What he shows us and what in how Ango is treated in the literature, and certainly in that literature, we see a change over time. We see initially the powers that be, and here I talk about the US in particular, which is really my foil for Ango in this paper. We see them champion Ango because they see him as a likely instrument for maintaining older structures against these pushes for a new international economic order. But as Ango proves elusive, the narrative changes to one of unreliability, of incompetence, of lies, of careerism, etc. We can read a lot through such reactions about the frameworks into which world-making projects disappear or are disappeared. And I would bring to your notice essentially four things. Firstly, the construction of the idea of competence. What does it mean to be a competent diplomat or lawyer? If part of the world-making endeavor was to bring into this work a thrust on political and politico-economic questions into the work of diplomacy and lawmaking, competence over time, and we see this happening at UNCLOS 3, is constructed to exclude such questions altogether in favor of a technical-only competence and embrace of corporate bottom lines. So Ango becomes a figure that is constructed as incompetent because he kept pressing on questions that the US, for example, considered irrelevant to what was to the business of achieving a workable international treaty. Then projects of world-making disappear into the composition of the treaty itself. So this is also an important question, right? With UNCLOS, as with other international treaties of the time, one of the questions you get is what kind of treaty is it meant to be? Is it meant to be a framework treaty? Then why are some parts of it so detailed? Why are other parts so vague? And here we find that the tussle over what to put into the treaty and what to keep out, what to place above the line, what to put below the line, what should go into annexes, into hortatory language, or into deferred and conditional promises. All of this matters because what goes in, what stays out, how things are couched are important to know for the ways in which they open and foreclose what you might do in the future. Finally, and the two further points, world making also disappears into choreography. So superficially, we have this new style conference, right, where things are meant to be done differently. We are moving away from older forms of world making. This conference is not going to be based on a text that the International Law Commission has prepared beforehand, for example. It's going to be a conference at which all new states are invited. Everybody will get to have their say. But behind this new style conference is a very old style shadow conference where the lip service is, well, although lip service is being paid to the making of this new order, the scramble behind the scenes is to ensure that nothing much changes, right? Things get displaced into, again, language that is hortatory, but things more or less lawmaking protocols, structures, and what the law does remains the same. This can be generative itself of new practices, for example, the consensus rule or package deal or other things, but it is worth keeping in mind that this is not then reflecting the world-making aspirations that third world states are bringing to the table. And finally, world-making disappears into crafted narratives. So UNCLOS 3 all the way was also about knowledge making. It was about circulating and controlling information, about developing a common sense of fundamental goals and interests. Reading through Ango, we see efforts to use him for that purpose, and also for the creation of narratives for what went right or wrong, what was a good draft or bad, what was a constructivist position versus an extremist position, who won or who lost. Essentially, projects of world making are then transformed into projects of those who are willing to work together to make a new, nice, liberal international order versus those who remain so opposed to it that they prevent the conclusion of a treaty, or as in Ango's case, end up delaying it to its eventual sort of only partial success. So stories of outcomes, stories of who were responsible. The world that is made with settled or closed ideas of competence or what is given or not in a treaty. It's made with certain clear ideas at the end of the UNCLOS about what counts as proper process, what is common knowledge, as well as what happened last time. And all of these remain material. They remain material to how we continue to think about the treaty and where it comes from and what it does in the present. So to sum up, what have I said today? I've taken Ango and talked about how he is written about as a point of departure, and suggested that we might use him to open up a number of questions. Through him, we might read a kind of history of life under empire, as also the post-colonial moment. We might read through him world-making endeavors of that post-colonial moment, and think about the world that was made and the kinds of questions, the kinds of epistemic and politico-economic closures that were achieved in UNCLOS 3 that end up shaping the world that was made, as opposed to the world that the third world states had hoped to remake. A further question, and I'm going to stop with this, is just why does it matter? Why does it matter in particular to law rather than to history? And the answer I would give you in terms of these two quotes, if we can accept that the things that hold we understand that if we think the present regime is not workable, and we understand that the things that hold us in place are factors that are both material and discursive, then it matters that we think about the narratives and the processes through which it was made. We see so materially, we know that moving away from the extractive imaginary is implausible because of the kinds of interests that are already vested in it, and that keep it in place, that keep it going, that keep sort of reforming it, even against pressures to try for change. One example of this you see in this first quote from the UN conference of 2017, which talks about the need for new lawmaking, but then says, we emphasize that this should be in accordance with, reinforce, and not duplicate or undermine existing legal instruments, arrangements, processes, etc. But the discursive structures matter as well. UNCLOS enjoys on top of the material factors that protect it and that ensure that not much will change, are discursive factors. There are this idea of the treaty as a constitution, the third UN conference of the law of the sea as a sort of unprecedented coming together of the international community, first world concessions to making a grand bargain with the third world, the gradual working out collectively from ignorance to knowledge, the move from conflict to agreement, from darkness to light. And that is the sort of narrative you see encapsulated in the second quote, which is from the Secretary General of the International Seabed Authority, where against pressures for, say, placing a moratorium on seabed mining, not doing it at all, he argues that this is a useless and a counterproductive argument because the international community has already made a decision and our job is to abide by that decision. If we start reopening those decisions, we're essentially reopening all that wonderful activity that went into making the constitution of our oceans. So I think it's important to puncture these narratives, to produce some dissensus in them, to think about what they actually code is the reality, how they present it retrospectively. And that's where I'll stop. I very much look forward to discussing these points with you. Thank you.
Thank you so very much, Dr. Ranganathan. I think especially on the point of the politics of international law, the title of the series, you had so much to say about this, including ignoring politics or pretending you're not doing politics as lawyerly competent, that's what makes somebody a competent international lawyer. I think that was, to me, that's a very interesting thing to take away from your very rich talk. I will not take any more of your time. Professor Rothwell, the floor is yours.
Thank you, and good evening, everyone from Canberra. Can I also just commence by acknowledging the point that Dr. Ranganathan made in terms of the passing this week of Judge James Crawford. Of course, Judge Crawford was an Australian citizen nominated to the court by Australia, and his loss is very keenly felt not only in Cambridge this week, but all across Australia in international law circles, including here at the Australian National University. I'm going to just ask Dr. Ranganathan two quick points of clarification, I think, just so it can assist us. You quite rightly referred to the role of Ango as chair of the first committee. And to that end, there's a very important Australian dimension, as you know, because the rapporteurs of the first committee were all Australian government officials and diplomats. But my quick questions were, if you could just advise us in terms of your understanding as to how Ango was elected or appointed as the chair of the first committee. And then secondly, what is your understanding of his working relationships with the vice chair of the committee, the vice chairs?
Thank you, Professor Rothwell. So in answer to those questions, how Ango was elected, this, I think there's a sort of official and a behind the scenes story. Let me tell you the behind the scenes story that at least the archives show up first, which is that one of the things we get is a document which records a meeting between US officials and an official from the UN Secretariat, where they're going through names of who would be good people to chair various committees, the three committees that would be set up for UNCLOS 3 following the equivalent three committees of the preceding Seabed committee. Ango's name naturally comes up because he had been chair of the equivalent subcommittee of the preceding Seabed committee, but a couple of other names are also mentioned. It's already clear by this time that the idea would be, because this is going to be seen as this moment of post-colonial lawmaking, that these positions would be given to essentially representatives from Asia, Africa, Latin America, and Eastern Europe, and one of the seats would be reserved for someone for Africa. So they are discussing likely candidates, and alongside Ango, I mentioned a few others. At this point, the US and this official from the UN agree that the most constructive person from their point of view would be Ango. He would be better than some of the other names who might be less controllable or too radical, less predictable at any rate. So that's the sort of behind the scenes story. Officially, UNCLOS starts with this idea of, so there are a number of positions. There are vice presidencies, there are committee chairs, and there are seats on the drafting committee. And every state should get the state should be able to get one seat on any one of these things, with, again, certain positions earmarked for candidates from Africa or from Latin America or Asia or Eastern Europe. Committee 1 falls to an African candidate. Ango is the name proposed, and he's elected by acclamation. So there are no questions. The complicated thing that happens at this point is really not about Ango, but it's about the US and the USSR both wanting chairs on the vice presidencies, which is to say on the General Committee and on the drafting committee. So they managed to persuade Amerasinghe to introduce a new formulation that will allow them to stand to not only get the first seat, but also stand for election for the second. And so they are the only states who end up with two seats in the conference structure. Everybody else gets one. Ango is non-controversial. In terms of his relationship with his vice chairs, this is an interesting question. I'd like to know more from you. What I have found is that there are lots of complications that arise, that at least the record shows, in terms of his relationship with Christopher Pinto, who is from Sri Lanka, who is quite a sort of active member of the Seabed committee. He chairs some of the informal working groups of the first committee, notionally under Ango. But as it turns out, and again, this is what you get from the archival records, what's happening behind the scenes is a lot of choreography. So at one point, the US is trying to use both Ango and Pinto as sort of conduits for the US position into the first committee. For a while, they think the two can work together. Then it turns out that there are tensions between the two of them. So they work with each of them. They try to work with each of them sort of bilaterally, but not telling them about meetings, or at least not telling Ango about private meetings that are happening with Chris Pinto. At various points, Ango feels that the informal working group is sort of taking away from the formal authority of the chair. And so there are tensions relating to that. There are also some tensions between Ango and Jens Evensen, who sets up an Evensen working group later on in the conference. So there are sort of interpersonal conflicts. I haven't found anything very concrete that brings the official vice chairs into the picture very much in the records, and that might be that they weren't running the sort of informal groupings that Ango was most worried about.
Thank you for those clarifications. I guess it's important to reflect upon this series in terms of the politics of international law and why this negotiation in particular is relevant. As our chair indicated at the start, I did a lot of work, and I continue to do a lot of work on Antarctic issues. In fact, that was the area of my PhD that I completed under Judge Crawford. And rather remarkably, the Antarctic Treaty was negotiated in 6 weeks. But the Antarctic Treaty negotiations only involved 12 states, and it resulted in a treaty with only 14 articles. So the size and scale and the dimension of the issues are vastly different to those that we're confronting here. And I guess relevantly, the only African state present at the negotiation of the Antarctic Treaty was South Africa. So the reason why we think about these issues, I think, in the context of the law of the sea is because it still remains the largest and most expansive and probably the most sophisticated international lawmaking event that we've seen. It went for many years, and even though its culmination is dominated by the story of the Reagan administration and ultimately the US seeking to not sign the convention, it's still considered to be an enormous success. And to that end, in terms of the figures associated with the convention and the conclusion of the convention, it's predominantly, not exclusively, but predominantly Tommy Koh from Singapore, who is the figure who is most often associated, quite rightly, with bringing the convention to a conclusion. And I think the value of your work and this discussion today is that it's shedding light and making us recall the role that others played in the process. So I guess I just wanted to make some reflections then about what's the value of this sort of analysis and discussion for events in 2021. So since the conclusion of the convention, of course, we've seen additional multilateral negotiations take place in the context of the law of the sea. We, of course, had the UN-sponsored negotiations for the so-called implementing agreement, which sought to broker a resolution to some of the issues involving the seabed issues, as you know, associated with Part 11 of the Convention. And then we had the fish stocks agreement, which was contemplated as an additional element to the Convention, but addressed issues that weren't addressed in great detail at the conference that you've discussed. And both of those brought about successful resolutions of issues. And then currently, of course, we're going through another multilateral negotiation, which will presumably eventually see the adoption of a legally binding agreement for areas beyond national jurisdiction, the so-called BBNJ negotiations. So the law of the sea multilateral negotiation diplomatic history doesn't end in 1982 in Montego Bay, because technically that's where the negotiations concluded on 10 December 1982. But in fact, they've continued, but of course with different delegates and with different political power struggles existing and different issue areas and different dimensions associated with that. Rather interestingly, given my earlier observation, it needs to be acknowledged that the current chair of the BBNJ negotiations is another Singaporean diplomat. So there's some continuity in that regard. So I'll make that observation, but I guess the other point I'd be interested to just raise before I ask one particular question is, of course, what's the significance of all of this for states that didn't exist during these negotiations? And quite rightly, you referred to the role of the G77 and Ango's role as a West African and an African delegate. But of course, in our region here in Australia, we've had the emergence of Timor-Leste as a newly emergent state, and it's imbued the legacy of all of these negotiations in terms of the Law of the Sea Convention, which Timor has ratified, has acceded to, I should say, and which it to a degree is the beneficiary of, but it cannot unravel many of these debates and discussions. What about the potential impacts for newly emergent states, which would have very significant maritime dimensions? And here I'm thinking about the potential in the future of an independent Greenland. What about the potential for an independent New Caledonia at some point in the future, which would clearly be an archipelagic state if it was to emerge as an independent state from France? So the observations and the debates and discussions that you've raised should not just be seen in the historical context of the third UN Conference on the Law of the Sea, but as I've said, one which creates significant legacies. And as you rightly point out, and you referenced a quote there from Michael Lodge, we're seeing some of those significant issues play out in the context of the role of the International Seabed Authority, and ultimately what we might anticipate in terms of deep seabed mining within the area taking place in the foreseeable future. So I guess my specific question then, framed against some of those preliminary observations, is what role do you think we can, or what can we learn from the role of Paul Ango as an oceans diplomat for the current BBNJ negotiations that I've referenced, and even a future UNCLOS 4? Now, I'm not suggesting that there will be an UNCLOS 4, but there's ongoing debate and discussion about that. So what are those legacies and what consequences and what lessons can we learn from Ango's role that you've outlined in your paper today?
So thank you. Those are really a very rich set of reflections, and that's a great question, because the real question then is, what are we looking for, right? I mean, the reason why the history is interesting, why it's UNCLOS 3 is important to look at, is really two things, or maybe three things. One is, when you look at what's happening in the present, there's a very real sense, if you go to, at the BBNJ negotiations or at the International Seabed Authority, they take place with a sort of, in a sort of ahistorical way. There is an absence of history in the room, or there is at best a kind of a crafted narrative that is taken as the consensual history, right? So the UNCLOS becomes this unquestionable treaty because they don't really look back much into how the sausage was made or what it ended up doing. And this brings me to the second thing of why this is important, right? So what are we looking for? Are we thinking with the sort of liberal internationalists of the time, for whom it was about getting a treaty, regardless of what compromises would be needed to get a treaty? That was how success was measured for a number of people. It was sort of uppermost for a number of delegates of the First World, but also those that the First World liked to call the moderates of the Third World. Coe is an interesting figure here because to some extent he was portrayed, the West, I think, saw him as a liberal internationalist, as a man who would make the practical compromises necessary to secure a treaty in the end, with the sense that a treaty was better than no treaty. But Coe himself is actually different from some of the other so-called moderates of the Third World, in that his view of Ango he didn't join this sort of negative consensus around Ango. For people, I think for him, Ango was actually at different points quite a productive figure for essentially doing the things he did. It allowed for Coe, so the difference here I'm thinking of is between someone like Coe versus Tommy Coe versus Amara Singhe. Amara Singhe clearly had tensions with Ango. For him, he was the initial conference president. Getting a treaty was important. The liberal internationalist narrative mattered. So for him, people like Angos were sort of sticks in the mud who wouldn't allow something practical to replace something that had been idealized. For people like Coe, or for people like Joseph Barrioba, who became the president of the preparatory committee that was set up after UNCLOS 3 concluded, for figures like Patrick Robinson of Jamaica, or indeed for Mohamed Bejawi of Algeria, or Chimney, other people who were either observers of the conference or participants in it, just the treaty or getting a treaty at the end was not sufficient. The question is, what interests, what would be the substance of that treaty? What views of the world would it reflect? For them, what mattered about UNCLOS 3 and about this lawmaking was that it was seen as this moment of epistemic openness. Not only could it produce a different account of the ocean and in whose interests it would be used, but also perhaps have ramifications for how international law and how it was made was thought about more generally. What happened by the end was, in a way, this narrative of tragedy. The end was the opposite of what had been. So yes, there was a treaty in the end. Yes, these states, the Third World states voted for and signed the treaty, ratified it. But what the things that had been hoped for from the treaty didn't come to pass. What ended up being consolidated was a different idea of how treaty negotiation should go, or what was important was getting a compromise. As we know, the compromise was further than sort of shredded in the 1994 negotiations that followed. What also followed was, so we had started with this idea that this lawmaking should be this open endeavor, everyone should be included. We see by the end, different principles emerge of who should get to say what, how much power chairs should have in the making of a treaty, what should a chair's role be, which have continued to dominate later developments. So the 1994 agreement around that sort of revised some of the Seabed provisions started in a very different way from UNCLOS. It began as a closed negotiation with 30 states and was gradually opened up to more states, but with a very different sense of how much chairs or individuals could affect the course of the negotiations. Already by the end of UNCLOS 3, actually, the powers of the chair had been stripped down to make sure that mavericks like Ango couldn't play spoil sport. And we see some of those logics continue to the present day. So there is a sense when the BBNJ negotiations take place, or the ISA is formulating its Seabed mining code, very strong sense that some questions are completely off the table. There is a certain idea of what the UN Convention on the Law of the Sea and its related treaties are for. The bottom lines have been set, the frames are given. What can happen is some degree of lawmaking now within those frames. So the generative moment really goes back, is really the late 60s, early 70s, where the question of what these frames were to be was also available to be discussed. Now it's not available. I think this is one of the reasons why it's quite important to look back at the history, but also to think about the contributions of figures like Ango, because people like Ango kept this question going long after. Again, you get this in the narratives of the conference, long after some of the Western observers had concluded that the time for these questions had passed. So already by 1974, 1975, you get a lot of literature that is saying, well, we now know what the directions of the law of the sea should be, or what is necessary for a workable seabed regime. Here are the things that are settled, and now it's a question of working out the details within that. People, Ango is one of the people who kept playing spoiler to that, kept bringing back sort of different ideas of what the common heritage principle should mean, what kinds of what priorities seabed mining should reflect, and so forth. So another reason why thinking about why his thinking with him is productive, as opposed to thinking with some of the other more moderate, so-called moderate delegates. But there's also this sort of there's a further question, and this is the question, so it relates to the second question you asked. When you ask what about new states, UNCLOS 3 was interesting precisely because it was actuated but the new states was what actuated that conference as well, right? There was a sense that now that the shape of the world has changed, the old law had been very particular in terms of the interests it represented, the interests it protected. The new law had to cater to a whole new set of actors, a whole new set of interests. It ended up not doing that. We now have a situation where we're again thinking about new states who are again going to a large extent, they have to buy the consensus that, or the rules that had been codified in this time. They are interested actors. There are lots of questions around, what claims they can make to their surrounding maritime, resources and to maritime spaces. But I don't know if what you see in terms of the epistemic openness towards how much that interests will end up reshaping the regime, or will simply have to work within the structures that they now inherit as these states that come into a world where much of the law of the sea is codified, is very clear. The ways in which it can change are only ways in terms of making sense of how new resources like marine genetic resources can be accessed, or making sense of some of the changes that are acknowledged in the world. So changes of sort of rising sea levels, changing baselines, those can change some of the rules. But to what extent are new states now seen as a driver of new law as opposed to the 1950s, 50s and 60s, I'm not sure about anymore.
Thank you so much, Surabhi, and thank you so much, Dawn. We still have 5-6 minutes. I might use my chair prerogatives and take us a little bit over 6, because there is 2 excellent questions in the Q&A that I want to also put on the table. So Daniel Kivi is asking whether Ingo lived to see the Lomé Charter on the Sea from the African Union, and regardless of that, whether you think that the Lomé Charter promoted his anti-colonial visions, and whether the African Union did enough to move away from the colonial infrastructure.
I think that's a very good question. So Ango died in 2010, right? So he was with us. He's a figure in that sense. He's a figure from more recent histories, unlike some of the others who were figures really alive till the 1970s and then vanish. This is a figure who lives through all of these transitions that we see over the course of the 20th century. The Lomé Charter question is an interesting. I would say that is an example that is often given as an example of, look, here is what works, right? So it falls very much within that sort of, so this is, its practicability is viewed through the lens of, again, it basically fulfills some of the liberal, international aspirations for what a treaty should be and should do. So which I suppose is my way of answering your second question, does the EU do enough? Here is why, again, thinking with the UN Convention is important, because I'm not sure what space remains open. So the EU is, of course, resisting colonial infrastructures in all sorts of ways, but as far as things like the law of the sea are concerned, as I said, the epistemic closure has happened. It happened in the 1970s. Things work within the framework that has been created. So this sounds like a very pessimistic answer, but my answer is that here, yes, I don't want to denigrate the efforts that are being made, but I don't think that the Charter does all that it is supposed to be doing.
Thank you, Surabhi. And the second question is by Douglas Guilfoyle, who praises your paper. He says it's wonderful. And he asks you whether you would like to say a little bit more about the so-called shadow conference and the common Western narrative that much quote unquote productive work was done in informal groups and processes, such as the Castañeda group or the Australian sponsored boat paper.
Yeah, great question. Thanks, Doug. I mean, the written draft of this paper goes into this in much greater detail than what I've said today. But one of the things I look at is, and reading, I sort of offer a chronology of what went down in terms of conference choreography by looking at how reactions to Ango were consolidated. What you get very clearly is two things. Firstly, the conference, most of it, the important parts of it happened off-site, right? What was going on in the plenaries was actually things that were choreographed in advance. You have, the archives are surprisingly clear in this. You also get a sense very clearly that some of the discussions are just happening for the purpose of, for a very, in a sort of very, very formulaic sense. The real work is being done in the shadows. But so that's, and there are different groups at different points. So to start, there is, there's the Brazil group, then you have the Castaneda group. You have sorts of different meetings that different formations develop, different groups of states come together in different little groupings to do most of the sort of hammering out of what the text should be. The interesting thing is, for me, is how. So the fact that there is a shadow conference is, of course, recognized in the literature, right? Nobody is disputing that, and it is the nature of most of these negotiations that what is happening in that big conference hall will be to some extent what has been choreographed in advance. The real work would have been done in the offices of the corridor. What is interesting is how this work off-site is represented in the literature. When I started reading material on the law of the sea, one of the narratives that you read most often is, and this is a narrative of why Ango was seen as such a problematic figure, is that, oh yes, initially Ango and a bunch of other third world delegates worked together with a bunch of first world countries like the US to come up with a workable draft in between 1974 and 1975, and then Ango, for careerist aspirations of his own, reneged on the draft and substituted what had been worked out by all of them together with his own draft. Similarly, that he did the same in a second time around in 1976, 1977, again reneged on the draft, produced his own. And after this, the US basically gave up on him because he was seen as this completely unreliable person, but also a man who clearly perhaps didn't know what he was agreeing to in these rooms. What you get from the archives is that the same idea of what the work that is happening offsite is the reality of it, right? So you find out that actually this is not about Ango and the US working together on this first draft in the first place. The meetings that are happening between the G5, so the USSR plus 4 Western countries. They are working out certain positions, but the US is working out some of its own positions internally, which it's trying to feed to the G5. It's using Ango. He's not part of the negotiations. He's been given these positions to feed to the rest of the world, as to the other states, as his positions. And he basically seems to play the game for a while on the surface, but is quietly working on the side with a couple of other third world countries and coming up with his own draft that he quietly substitutes, which he can do in his capacity as chair. So there is a shadow conference that is acknowledged and written about, and then there is a shadow conference that emerges through the archives, which actually competes with some narratives. It shows two things very clearly. One is how much the US especially tried to control the negotiations. This should not come as a surprise, but it is shocking sometimes the language in which the US describes what it's doing or how it's writing about delegates, or the clarity with which it expresses its own sense of the importance of fundamental US interests and how much they should be in the treaty. The other thing you get, and this is also really fascinating, is that this is a game of smoke and mirrors where common knowledge is being fabricated about the law of the sea, right? So at various points, the US especially, again, is trying to produce an idea of who seabed mining will be good for that doesn't quite relate with the facts on the ground. And you see them therefore trying to interfere with other delegates' sense of what is in the sea or what would be a good economic model through either running tactical seminars that will present information differently, or when there is a seminar that, say, someone like Ango has organized that actually tells third world states maybe seabed mining is not actually going to be in your interest for all of these reasons, producing sort of asking disingenuous questions that are meant to muddy the understanding. So the shadow conference is also going on in terms of there is private knowledge about how seabed mining will work, but there's a kind of public knowledge that has been created that differs quite a lot from it. And that's absolutely fascinating. That's the thing I hope I might draw more in my paper, because that leaves us with, therefore, the senses of what are the given bottom lines about seabed mining, right? It's not that we then thought it was a wonderful thing and now we know that it's terrible for the environment. Even the politico-economic dimensions of it back then, it was pretty clear, at least privately, that they weren't nearly as beneficial as they were set out to be. So why was this project being pushed in the first place, and in whose interests?
That is really fascinating. Thank you so very much. So we are in 2 minutes actually now, after 6. So I think we don't have any questions from the audience. I think I'm going to conclude the proceedings. I'm going to really thank Professor Donald Rothwell for his very generous and close engagement. And of course, our speaker, Dr. Ranganathan, thank you so much. It was really generous of you to share, especially the wealth of your archival research. I think this is really fascinating to see, even for someone who knows nothing about the law of the sea. I think that really came through, and I think I'm really looking forward to reading whatever you produce at the end of the project. Thank you all for attending. Our next seminar in the series will be on the Friday, the 16th of July, when Professor Machagai Selef will be talking about international law, contagious diseases, and race. Thank you all very much.
Thank you. Thanks so much for having me, and thank you, Professor Rothwell, for your engagement.
You're welcome. Bye.